Good morning. Today we are going to deal with the subject winding up of a company. Let's start with the meaning and definition of winding up of a company. As you all know that company's creation and two companies winding up, it is a big process. As we have already discussed the creation of the company and the aspects and features which are required for the creation of a company. Now, after creation of a company, when you start its business or you commence its business, and you one time comes, you feel that it necessary to wind up the company. Wind up of the company in Marathi means कंपनीचा कंपनी गुंडाळणे, कंपनी समाप्त करणे, कंपनीचं अस्तित्व समाप्त करणे. So, as far as the creation of the company is considered, the legal procedure and compliance of that legal procedure is very important. In the same sense, you cannot end the company, you cannot leave the company at once at the moment's notice, you cannot throw the company. It is also one of the legal procedure has been prescribed for that. So, winding up, to study winding up or to dissolution of the company is a process by which the company comes to an end. The formation of the company or the status of a company as a legal person comes to an end. And company is dissolved, companies all the assets and liabilities are distributed amongst its shareholders, and if any credits in the name of the company is on due, then it is also to be satisfied up. And for this process, a liquidator is to be appointed by the shareholders or the owners of the company to comply all the process and legal formalities. Now let us discuss what is meant by winding up of the company. The winding up, it is called in other words liquidation process. Liquidation and winding up is the synonymous to each other. So liquidation of a company means bringing to an end the existence of the company. The corporate entity of the business enterprise comes to an end. The winding up is a process by which the company is dissolved. So dissolution and winding up, there is a difference between these two words. Winding up is a prior term, prior process, and dissolution is the latter stage or the end stage in this process. According to Professor A. Ramaya, winding up has been defined as it is a means by which the dissolution of the company is brought about and its assets are realized and applied in payment of debts, company's debts, and after satisfaction of the debts, the balance, if any remaining, is paid back to the members or the owners or the shareholders of the company in proportion to the contribution made by them to the capital of the company. According to Professor Grover, winding up or the liquidation of the company is a process whereby the life of the company comes to an end and its property, the company's property, is administered for the benefits of its creditors and members. So, very simple definition has been given by these two legal scientists. Winding up is a means by which the dissolution of the company is brought about, according to Professor A. Ramaya. And according to Professor Gover, the winding up is the process whereby company's lives comes to an end or is ended and its property is administered for the benefits of its creditors and surely its members. Now let us see the what is the difference between these two terms, winding up and dissolution. So though the terms winding up and dissolution are sometimes used in the same sense, technically they have different implications. These two situations differ in following circumstances or in following conditions. One is winding up precedes dissolution. In former winding up, the company still remains in existence, but the latter implies the company will not exist anymore. It comes to an end completely. So dissolution is the latter stage, final stage, and winding up is the starting phase or stage where under the process of the company's dissolution is started. So keep in mind always that winding up is the process by which the company is ended, and after the complete legal process of ending the company, the dissolution happens. So this is the main difference. Winding up is the first stage and the dissolution is the latter stage. Winding up is the process of starting the dissolution, and dissolution is actually final stage of the completion of the company's dissolution process. Winding up involves liquidator's act of realizing the assets, satisfying the debts and obligations, distributing its capital and surplus money or property among the members of the company. So winding up says that it is a process whereby the liquidators are appointed by the company's members for purpose of acting of realizing the assets, satisfying the debts and obligations, if any, in the name of the company, is if it's in existence, and thereafter, if any, after satisfying the debts of the company to the creditors, if any amount or property or balance is surplus or remaining, then it may be distributed amongst the members of the company. And dissolution comes after the liquidator has done all this first step process of winding up. Third is the liquidator in case of the winding up is the representative of the company on behalf of which he is appointed. But on dissolution, liquidator cannot be anymore a person who is represented or a representative of the company, because the company after dissolution doesn't remain in existence. Its legal status comes to an end completely, and when a legal status of the company comes to an end, then automatically the power of the persons company to delegate the persons, to appoint the persons, or to make a contract with the persons also comes to an end. Now let us see what are the implications of the winding up. Winding up is more popularly known as a liquidation of the company. It has the following implications: all the company affairs are wound up, all the company affairs are terminated, company's existence are comes to an end, its rights and liabilities are discerned, and the claims of its creditors are settled either fully or to the extent warranted by the assets of the company. And if the surplus of any money or property is in the hands of the liquidator, if remaining after satisfying all the debts to the creditors which have been taken by the company, then that may be distributed among its members in the proportion of their rights. Now let us see what are the modes of winding up of the company. So winding up of the company under part 7th of the Act deals with the winding up procedure. Under section 4 to 5 of the Companies Act 2002, a company may be wound up. Under section 270 of the Companies Act, winding up is of two types. One, a compulsory winding up by the tribunal, and second is a voluntary winding up by the members, voluntary, or the creditors voluntary. So there are especially the two types of the winding up of the company. One is the compulsory winding up, सक्तीचं वाइंडिंग अप, आणि दुसरं आहे ते म्हणजे स्वयंस्फूर्तीनं स्वतःहून केलेलं वाइंडिंग अप. आता कंपल्सरी वाइंडिंग अप हे ट्रायब्युनल किंवा कोर्टाकडून केलं जातं, आणि व्हॉलंटरी वाइंडिंग अप हे दोन प्रकारे केलं जातं. एक म्हणजे कंपनीचे जे शेअर होल्डर्स आहेत, ओनर्स आहेत, मालक आहेत, ते स्वतः त्यांना असं वाटलं की कंपनी चालवणं हे जिकिरीचं झालेलं आहे, अशा परिस्थितीमध्ये ते कंपनीचं वाइंडिंग अप व्हॉलंटरी करू शकतात, किंवा तसा प्रस्ताव इतर सर्व सभासदांपुढे ॲन्युअल जनरल मीटिंगमध्ये ते मांडू शकतात. त्याचबरोबर जर कंपनी ही अतिशय खोल अशा कर्जात रुतलेली आहे, तर अशा वेळी मात्र कंपनीचे जे सावकार आहेत, क्रेडिटर्स आहेत, ते सुद्धा कंपनीच्या गाशा गुंडाळणे किंवा कंपनीचं एंड करण्यासाठी, कंपनी टर्मिनेट करण्यासाठी सुद्धा ते वाइंडिंग अपची प्रोसेस राबवू शकतात. Let us see the one by one the types of this companies winding up. Winding up by the tribunal or court. After the amendments to Companies Act in the year 2002 and also in the year 2013, the powers of the winding up have been conferred upon the tribunal constituted under Companies Act. The central government has to constitute tribunal consisting of a president and such other numbers of judicial and technical positions, and not exceeding 62 as it deems fit. The tribunal may order the company's winding up of a company on a petition submitted to it on any of the following grounds. So, for the purpose of, keep in mind that winding up of the company by the tribunal, tribunal means a court, compulsory winding up, then the petition or a appeal to be made to the court or that tribunal to make the company wound up. So for that purpose, a special resolution for winding up must be passed by the, when the company has passed a special resolution to wind up the company, but the tribunal may not order liquidation if it is opposed to public interest. So for that purpose, a special resolution must be passed by the company, and that must be submitted to the tribunal or a court of law, and then and there only the court or tribunal may take an action of or pass an order of liquidation. And again, if it is in the if it is not opposed to the public interest or public policy. Thereafter, special resolution according to section 271 lays down the following grounds where company may be wound up by the tribunal. One is a special resolution, as I told you. Second is a default in statutory meetings, conduction of that meetings. If any company makes a default in holding a statutory meeting or submitting a statutory report to the registrar, to the tribunal may make order for winding up of a company. Inability to pay debts. As I told you earlier, if the company is unable to pay its debts, or the debt has been taken by the from the creditors, then the creditors make an application to the court of law to dissolve the company also. Failure to commence business. A company may be wound up if the company doesn't commence its business within 1 year from the date of its incorporation or registration and suspends its business for a year. Just and equitable reasons. The tribunal may order the winding up if it is of the opinion that it is just and equitable that the company should be wound up. For instance, continuous losses, operation on minority shareholders, or a deadlock in management, or any other reasons which says or which leads to the company's loss or company's destruction, then these are the or can be the proper grounds for such a passing of an order of winding up of the company compulsorily. Default in filing returns. If the company doesn't file returns with the registrar and its balance sheet and profit and loss account or annual returns for any 5 consecutive financial years, Then also court, after making an application or appeal or a litigation, then the company's law board or company tribunal can make a order of or pass an order of dissolution or winding up of the company. If it is if it is opposed to sovereignty and integrity of the nation. If the company's workings, if the company has acted against the interest of the sovereignty and integrity of the country, our country India, then the security of the state or any relations with foreign states and public orders, decency or morality, etc., then the tribunal may compulsorily wind up of the company. Also, tribunal can wind up of the company if the company law board or if the tribunal is of the opinion that the company should be wound up under the circumstances specified in section 424 subsection G of the Act. An application or a petition to the tribunal for compulsory winding up may be made by the company, its creditors, shareholders, or all or same of them together. Such petition may also be filed by the registrar or with the registrar or person authorized by the central government. Now let us see what are the powers of tribunal. The tribunal appointed under this act has the following powers. First of all, the tribunal, after making an application by creditors or by shareholders or by any other persons or body authorized by the company to the tribunal, then it, on hearing a winding up petition, the tribunal may dismiss it with or without cost or adjourn the hearing conditionally or unconditionally or make any interim order or a temporary order that it if it deems fit or make an order for winding up of the company with or without costs or any other order by following the due compliance or due procedure of the CRPC Civil Procedure Code of India. Where the petition is filed on the ground that it is just an equitable to wind up, the tribunal may refuse to make order if it is of the opinion that alternative remedies available to petitioners. If the petition is presented on the ground of defaulting in filing statutory report, then tribunal can direct that the report shall be delivered or submitted to the registrar or the statutory meetings conducted conducted within the time prescribed by the tribunal. So tribunal may give a chance to the company, alternate chances than compulsory winding up of the company. It gives alternative chances to the company to correct the wrongs done by the company. It may also order that the costs should be paid by the persons responsible for such a default. Where the tribunal makes an order for winding up of the company, it shall intimate the order to the official liquidator and the registrar of the companies. So this is we have discussed the compulsory winding up of the company. Now, what are the consequences of this compulsory winding up order made by the tribunal? The consequences of the making of a winding up order was actually made, and the date is called the commencement of the winding up. The winding up commences from the time of the presentation of the petition. The company was its in voluntary liquidation from the time of the passing of the resolution for voluntary winding up. The various consequences of the winding up by the tribunal are as under. Intimation to official liquidator and the registrar is a must. The notice of in such regard must be given to the liquidator and the registrar by the tribunal. Copy of the winding up order to be filed with the registrar. Order for winding up deemed to be notice of the discharge. Suits stayed on winding up orders. Responsibility of the directors and offers to submit to the tribunal. Audited books of accounts. Powers of the tribunals are used and utilized herein. Effect of winding up order is that the company comes to an end and the dissolution happens. So these are the process. This is the process we have discussed of the compulsory winding up of the tribunal on an application made by the creditors or shareholders to the court or the tribunal, and it is a process specifically done by or followed by the tribunal. Now let us discuss the voluntary winding up, whereunder we have to first of all see the creditors voluntary winding up. There are subtypes: creditors voluntary winding up and the members voluntary winding up. So creditors voluntary winding up is a winding up of a company in which a declaration of its solvency is not made is known as a creditors voluntary winding up. What is meant by creditors voluntary winding up or winding up is the process when creditors can follow is in such a conditions that when a declaration of its solvency by the company is not made, then in these circumstances the company's voluntary winding up by the creditors is to be done. In this process, uh, first of all, the meeting of the creditors can be convened up. So let's discuss the procedures of creditors voluntary winding up. First of all, creditors meeting should be held on. A company will call a meeting of the creditors of the company on the day or on the fixed next day of the annual general meeting of the members. The board of directors will present before the creditors a full statement of the affairs of the company, the management and the administration, and the loss and profits, etc., of the company before the creditors. Then notice of the meeting of the creditors must be given to the registrar within the 10 days. Thereafter, the appointment of the liquidator is to be done by the creditors. The creditors may nominate a liquidator for the purpose of winding up of the company, for the follow the procedure of winding up of the company affairs. Thereafter, appointment of the committee of inspection. The creditors also at their meeting they can appoint a necessary committee of inspection consisting not more than 5 persons for the purpose of follow due procedure. A liquidator's remuneration also can be fixed in this meeting by the creditors. And on the appointment of the liquidator, once a liquidator is appointed, liquidator can be a person or a body of persons. All the powers of the board of directors, the management of the company shall cease or come to an end, and all the powers will be vested in the hands of the liquidator. Now it is the liquidator's duties to follow the procedure and take or lead to a company to the wound up process or to the end of that company's existence. In these circumstances, after appointment of the liquidator, he calls a meeting of a general meeting of the company and creditors, and at the end of each year, and then a final meeting to be held by him regarding the company's affairs, and after all, and later, eventually, the company is to be comes to an end with the passing of an order by the liquidator. Now let us see the consequences of the voluntary winding up of the company by creditors. Winding up affects a number of parties. The consequences of winding up are as under: one, consequences as to shareholders. So shareholders, as far as the shareholders or the owners of the companies are concerned, after following the due procedure, after following or complying the dates taken by the company or satisfying the dates company has taken, the liquidator, if any sums or if any amount remaining in the hands of the liquidator, then it can be shared or distributed among amongst each shareholders. Creditors, as far as the creditors are concerned, the creditors are its themselves are conducting this process. So if any amount they due to them by the company, then first of all they make them free by getting this amount whatever they have given to the company. Consequences as to the servants and officers, so their duties and their jobs are stopped, and they are unwillingly, we can say that they can be stopped from their working, they are terminated from their jobs. So this is to be, we have discussed the consequences of the winding up. The company comes to an end completely. Winding up is the first stage, whereas the dissolution is the second stage, latter stage. We cannot say, we always utter or pronounce, we replace the words dissolution for liquidation or the winding up for dissolution. But these are the two different terms. Liquidation or the winding up is the process, whereas the dissolution is the actual end of the company, legal end of the company. So I think, I hope that you have got my point. If you have any doubt, then you feel free to contact me or say any doubt through my mail or through WhatsApp. Thank you very much.